Hi everyone, this video is to review last year's midterm exam, and I hope you have all had a chance to try to do Part C, okay, because that's really critically important. If you just look at Part C, listen to the video, look at Part C, listen to the video, you will not learn how to identify those things, because I won't be there on the day of the exam saying this is this and this is this, all right? So anyway, having said that, we'll take a quick look at Part A and Part B. I don't plan to do very many of the questions, if any at all, because you can do them, and then if you have questions, you can contact me. Part A is 15 terms, and you have to pick out the best definitions. And last year, you'll note that I think when you're doing it, there was some confusion that substantive law could actually have been D or L, so it didn't matter which one you put down. I gave you the marks. The problem with Part A is you don't have a lot of time, okay? And the reason that I don't give you all weekend to do the exam is because you could just sit there and eventually find the material and hand it in, get a good grade, and bingo, what have you learned? This way you have to learn the material. So you'll be able to go through these terms and say, okay, I know juridical person, I know sovereignty, okay, I know legal publicus, a torn, leave that one blank, I know stratus, and you get all the ones that you know, and then you go back and you say, okay, I have to find out what a torn means, and then you can probably Google that one, although it is dangerous. Okay, so, and then you'll spend the minimum amount of time on that, and then you go into Part B, and you've got more time to work on Part B. So I really suggest that you handle it that way. Now in Part B, question 1, you have to remember that this was an in-class exam, and it was closed book, and so I asked questions like list things, that I think you should know. Whereas on this exam, because it's open book, having you list things would be kind of ridiculous. You know, list 5 different cars in the world. Big deal, right? So I'll be looking for more detailed answers, probably through more detailed questions. Question 1, you do not know what's coming at you. And so you have to look at certain areas where there's a substantial amount of material that I might, question you on. For example, there's a lot on arbitration, and last year it was jurisdictional doctrine and proper law doctrine. So those are big packages of information that would make a good 10-mark question. The other questions, though, are 5 marks each, and I'm as lazy as any other professor. I'm not going to work and sweat and everything for 6 hours figuring out the perfect 5-mark question. I'm going to look for something that has sort of 5 parts to it. Okay, so in question 4, for example, where it says there are 2 ways of entering foreign markets, passive and active, list 3 specific operational strategies. I was looking for things like distributors, outsourcing, direct sales. It's an easy 5-mark question. And as I went through the topics when I was lecturing, hopefully I highlighted a few things. But you can go through and pick out some things yourselves and basically draft answers. You're not sure exactly how I'm going to word the question, but you can at least get the material ahead of time. Okay, I'm not going to ask the same questions in the same way, but for example, question 7, if PPP sued a business and obtained a judgment, how do they levy execution? What 4 things can they do? Well, I'm not going to ask that question again. I mean, why would I? I'm trying to get you to learn things, but I may ask that question as part of Part C, for example, where some company is suing somebody, and then what are the options for collecting on a judgment, that sort of thing. Enough said on Part A and Part B. Part C, however, I'm going to spend a fair amount of time going through, and again, all you're going to have to do basically is fill in blanks, but you're going to have to think. Okay, Part C is where I try to find out if people not only can either know the material or look it up quickly, or or whether they actually can apply the knowledge. So what we have here is a young lady, May I Sue, has been hired by the Department of Justice, and her boss is Reginald Writ, as in writ of summons. And this is her first day on the job, and she goes in and she meets Elizabeth Pendings. And Elizabeth Pendings says, please call me Liz. Liz Pendings is a legal term. So I'm having fun with these, okay? And the funny thing is I do this every year, different what I think are quite humorous things, and nobody ever says anything about it, you know. And I think about a product like Peak Performance Pontoons, which, you know, is like right off the wall, and it's interesting. Nobody's ever thought of it before. Nobody ever mentions, wow, you know, what a neat thing to do, you know. I should just do what Harvard University does. They have a widget. What's a widget? A widget is nothing. It's something they made up, and they use it in all their business scenarios. Big deal, a widget, you know, like. So anyway, I've got a, you know, a semi-real product. Never mind. Anyway, so Sue and Pendens sit down at a conference table, and they're going to go through some files and decide what the Department of Justice should do with them. The first one is, and there's a memo on the front of the file. And the first one is a case where at the Los Angeles cruise ship terminal, the U.S. Homeland Security face recognition software malfunctioned, and a number of passengers getting off the Island Princess cruise ship were arrested and detained because the software identified them as terrorists, drug smugglers, or international criminals. Murderly Gertson, a mild-mannered Canadian from Wabaw, Saskatchewan, was confused with the infamous international jewel thief Francois Fingers Franco. Despite his protestations of innocence and those of his wife and children, he was arrested and taken to an undisclosed location. Homeland Security was convinced that Girdley and Franco were one and the same. While Franco had committed numerous crimes in Europe, he had not, as of yet, committed a crime in the United States. Sue said Homeland Security could not have taken jurisdiction on the basis of the something principle. Well, jurisdiction in criminal cases, it's either territory, nationality, universality, protective principle, or the passive personality principle. And the passive personality principle is seldom, if ever, used. So bingo, you're down to 4. Well, they can't take it on nationality, or they can't take it on territoriality, because Francois Fingers Franco is not a U.S. citizen, although it doesn't say so in the problem. You can probably assume that. But the obvious answer would be territoriality. No crime committed on the United States. Okay, so she says they couldn't have taken it on that basis. If this matter goes to trial, it will be in the something court in the United States. In the something court. What court? Municipal (criminal) court. Okay, the forum. With the proper law being that of the federal criminal court, or criminal code, because it's international in basis. So they have 51 criminal codes down there. They have one in every state plus one in federal, but Homeland Security is obviously federal. Okay. But I put in federal. All you had to put down was criminal code. So in criminal matters, it's really easy. You take jurisdiction on one of those 4 ways. Well, maybe passive if I get really creative. And then what's the forum? Well, the forum is always the Municipal Criminal Court. Okay? And it's always the Criminal Code of Canada, or that's applied in Canada. The Criminal Code of the United States is applied in the United States, because the United States would never take the Criminal Code of Canada and apply it here, or the Criminal Code of Bajanagistan and apply it here. All right. So, what should we recommend, said Sue. Pendens suggested the AG could make an application to the... you have to think back to the cases that we've had. This one would be an application to the International Court of Justice. Why? Well, how could they make an application to the criminal court in the United States? They have no standing. Okay. But you have standing in the International Criminal or International Court of Justice, and claim jurisdiction over Gerdson on the basis of the, jurisdiction, nationality, territoriality, protective universality. Territory? No, not in Canada. Protective? Well, maybe, but he's just a thief. Universality? No, he's not a terrorist. So that leaves, obviously, Gerdson is a Canadian, so you take jurisdiction on the nationality principle. That dispute resolution forum, the International Court of Justice, could use now the International Court of Justice has advisory jurisdiction and contentious jurisdiction. Are they going to decide whether Gerdson is criminally responsible? No, they don't have jurisdiction to do that. So this must be the advisory jurisdiction. You go to the International Court of Justice and you say, hey, look, this is a Canadian citizen. This matter is a mistake. What we need to do is somehow get jurisdiction over him. So the International Court of Justice would use its decision to claim that there is concurrent jurisdiction. Okay, they cannot say the United States doesn't have jurisdiction, but they can say both have. Remember SS Lotus, the French and the Turkey. France has concurrent jurisdiction, and so then diplomacy comes into play. Okay, and you try to get him extradited, the French first officer, back to France to stand trial. So you're looking at concurrent jurisdiction, and then an application can be made to the United States on the basis of the International Court of Justice decision, and you can ask for extradition. Okay, so then our Department of Justice could bring an application to the United States Department of Justice for an extradition order and have Mr. Gerdson brought back to Canada for trial. In a situation like this, the United States would probably be more than happy to get rid of him. Okay, I mean, if it's a terrorist, no, they want to fight terrorism. But an international thief, they don't care where he's tried. Okay, so they'd probably let him come back. However, Sue then suggested that maybe the first step should be diplomacy. And in almost all these problems, one of the first steps should always be diplomacy. Okay, so look for that. By having Prime Minister Trudeau call President Trump and explain that this is just a misunderstanding. Pindon said, wait, here's a memo in the file that says that has already been tried. Apparently, President Trump refused to take Trudeau's first 3 attempted calls. Finally, he did get to speak to President Trump, and Trump began to rant and rave about Nafta and how it was the worst deal the United States ever made. That was followed by a series of tweets. Here's a copy of one. Ronald J. Frump. Canada has always been soft on terrorism, which has nothing to do with Gerdson. Okay, but then, hey, that's Trump. This Murdley Gerdson guy has probably been a sleeper for years. He's from the Middle Eastern country of Saskatchewan, which is right next to Bajanagistan. Shame on Canada. And if you think that it would be odd that President Trump wouldn't know where Saskatchewan was, in the election between Bush and Al Gore, a news guy came up to President Bush and said, do you think Saskatchewan should be allowed to have nuclear weapons? And he said, no Middle Eastern country should be allowed to have nuclear weapons. He thought Saskatchewan was in the Middle East. Anyway, they asked Al Gore that, and Al Gore laughed and said, I don't think we have to worry about Saskatchewan. Unless they load their missiles with wheat or something like that. It was quite humorous. Anyway, so, that's not far off here. Anyway, going on, maybe we could call Prime Minister Boris Johnson of the United Kingdom and see if the UK could use its something to assist in making representations on Canada's behalf. Diplomacy. Diplomacy between Canada and the United States. Okay, they negotiate. Nothing happens. Some other country steps in and says, hey, can I get the two of you closer? That country is considered to be using its good offices. Okay, good offices. I doubt that will work, as though they already tried to contact Prime Minister Johnson, but there is a communique from him saying he was too busy. And it shows a picture of him working on Brexit. All right. That file is set aside. They take another file. The Pincher Creek Tortilla Manufacturing Company, along with the Canadian International Development Agency, had negotiated with the Mexican federal government to build an automated tortilla factory in the state of Jalisco. After obtaining the authorization from the Mexican federal government, the company out of Pincher Creek began to construct the plant, but after a substantial amount of investment and work had been performed, construction was halted by the state government of Jalisco, which claimed that the necessary state permits had not been issued. Jalisco then took possession of the facility and began to finish construction. The company out of Pincher Creek and CETA now faced losing the investment as Canada and Mexico have become embroiled in a dispute as to whether the provisions of Nafta applied to only relations between Canada and Mexico on the federal level, or whether it would also apply to the state of Jalisco. You think, oh my gosh, I don't know anything about the internal workings of the Mexican government. Absolutely not necessary, okay? What we've got here is an investment in another country by one company, okay? That investment is expropriated without compensation. How are these resolved? Well, you know, what you might want to do is, and I think I have it, yes, list from slide 41 the 6 ways that international disputes are resolved. So here we have 6. Pardon me. Diplomacy. Well, we'll get into diplomacy because they should do diplomacy. International courts. International Court of Justice, what do they got to do with this? Nada. Okay, so municipal domestic courts? No, there's no lawsuit going on here. Private arbitration? No, it can't be private. This is between governments. So obviously that leaves international arbitration and international tribunals. Now, I really don't see that there's much of a distinction here. I think it's more academic than otherwise, but this is from a very well-written textbook, and so I'm bowing to the fact that there's a difference between international arbitration and international tribunals. Obviously, this is under Nafta, which would be, pardon me, an international tribunal. Okay, so a binational panel would be set up. No, not anymore. Last year, that's what I would have said. Sue started off the discussion on the file by saying neither the Canadian Parliament nor the United States Congress had ratified President Trump's USMC trade deal, which was true at the time. So the North American Free Trade Agreement between Canada, the United States, and Mexico, which is a multilateral treaty, okay? You could say multilateral agreement. I would accept that because a treaty is actually nothing but a contract, is still in effect. This means we really have 2 issues here. The first is a dispute over the interpretation of the terms of Nafta. That's because they don't know whether it deals with just Canada and Mexico or whether it can be Canada and the state of Jalisco, okay? So how were those resolved? Well, under Nafta, let's see, do we actually write it down? Yeah, we do. Okay, under Nafta, Article 11 interprets the agreement, okay? Disputes between the countries as to the interpretation of Nafta is done by Article 11, all right? Let's make sure I'm getting that correct, because it's flipped over the page. Oh, pardon me. Article or Chapter 20 deals with interpretation. Okay, this is on one of the slides, and you can find that. Interpretation of the agreement under Chapter 20, investment disputes, Chapter 11, and anti-dumping, Chapter 19. Okay, all right. So let's go back. The first is a dispute over the interpretation of Nafta. The second is whether there should be compensation for the lost investment. Each dispute would be resolved by reference to an international tribunal or a binational panel. Okay, or a multinational panel, because there's 3 countries. To resolve the dispute, I think the matter has to go to a multilateral panel. So international tribunal is the method to settling disputes. Under Nafta, you set up either a multinational panel. Okay, if there's a dumping dispute like the Raspberry case that I've referred to in the video, then it would be a multilateral panel of what? Well, 2 Canadians, 2 Americans, and the chair would be someone from Mexico. In this case, what it would be a multinational panel made up of 2 Canadians, 2 Mexicans, and a United States representative would be the chair. Okay. And then the panel would look under Chapter 20, and they would determine whether or not the NAFTA agreement applied to Jalisco, or whether it's only between federal and state governments. This is right out of a real case, by the way. Just changed the names to make it funny. Hopefully funny. Anyway, and then once they've determined, whether or not it applies, then it would go to a multilateral panel under Chapter 11. Okay, that was last year. Okay, Trump destroys NAFTA. They negotiate a new deal. Most of NAFTA terms are still included, except they got rid of Chapter 11. I don't know why. Okay. Anyway, they get rid of Chapter 11. Well, what's that mean? Well, that means that Canada can no longer go to, I was going to say NAFTA, but it isn't, the Canada-US-Mexico agreement to get compensation. Ooh, what's that mean? Well, if you go back and look, the international arbitration method of settling disputes had one called the Convention on the International Settlement of Investment Disputes, set up under the World Bank. Okay, so strange as it seems, we have this multilateral treaty with the United States and Mexico, and if there's an investment dispute, it is resolved outside of that agreement, which I think is totally stupid. But then, hey, Trump is totally stupid. And I'm sorry if I've insulted some of you who are Trump supporters, but there's no cure for stupidity. Anyway, so this would be answered as follows this year. This matter would not go to international tribunal. It would go to international arbitration. Okay? And it would be irrelevant whether the United States, Canada, Mexico agreement applies to the federal level or the state level. And actually, Canada would be better off because it would just go to the World Bank's organization under international arbitration, and there would be a decision by the International Settlement, the International Center, the Convention on the International Center for Investment Disputes. So it would be a simpler answer. Okay. Continuing on. They went out to lunch. Liz Pendant dashed out, grabbed a sandwich and a Coke from a food truck, and then headed back to her office, where she took a telephone call from an old school chum, Donald DeFacto. DeFacto was now a junior associate with the BC firm of Dewey, Cheatham and Howe. After pleasantries, Donald said, "Thank you for agreeing to talk to me, May. I know you're really busy on your new job, but I really need to pick your brain. My boss, Henry Howe, gave me a big file to work on, and I need your advice. I have drafted 3 contracts, one between my client and the Whitecaps soccer team, okay, in BC, one between my client and a soccer team in the Duchy of Grand Fenwick, and the third with a Mexican soccer team, it should say. The client was selling clap hats to these soccer teams. Last year, the client sued a soccer company in Lower Slobovia, but his BC court judgment was not recognized by the High and Omnipotent Superior Court of Lower Slobovia. So my client wound up with a something and received nothing. Okay. So he got a judgment, but received nothing. So what would it be? It would be a dry judgment. Now the client wants to steer clear of court systems, which means I have to put in something clause. You don't want to go to court? What could it be? What's the alternative to court? Arbitration. Okay. This is a private company, so it's private arbitration. It's not international arbitration. It's not an international tribunal because it's not between governments. So it's private arbitration. So he wants to put in an arbitration clause. You get a half a mark. You want to put in a mediation and arbitration clause, or a med-arb clause. Okay. Well, the clause in the contract with the Whitecaps should specifically resolve disputes pursuant to a law, Arbitration Act. Okay, BC has an Arbitration Act which resolves disputes between companies in British Columbia. The clause in the contract with the team in Grand Fenwick should reference the Canada and an international company, so it should be the International Commercial Arbitration Act. And Nafta now has a provision in Article 2022, okay, not a chapter, just an article, which allows private arbitration disputes to be referred to the Commercial Mediation and Arbitration Center of the Americas, or CAMCA. I'll accept CAMCA if you're in a rush, okay? Apparently that's still there, but apparently not very many businesses know about it because it's not well advertised, and I think there's only been one dispute between U.S. and Mexico. There haven't been any in Canada, but it's there. Okay, so we got 3 different acts which solve disputes in 3 different situations. BC to BC, Arbitration Act. BC to international, other than the United States and Mexico, the International Commercial Arbitration Act, and then the third is under the U.S., or the Canada-U.S.-Mexican Agreement, and it's CAMCA. That's super, thanks. Is there anything else I should do? Well, in BC, BC is a something jurisdiction, and Grand Fenwick and Mexico are something jurisdictions. So you have potentials for, this will be in Part C somewhere. So you can actually, as well as listing the 6 disputes, you can also list other things that you can expect to look for. Common law, BC. Civil law, Grand Fenwick. And if there are laws of different jurisdictions, the problem is potentially a conflicts of law. That means you should include a something. Choice of law clause. And it should exclude what? Conflicts of law situation. Because in my video, at least I hope I did, I'm pretty sure I did, there was a Canadian company and a Missouri company, and they entered into an agreement, and there was an arbitration clause, or a choice of law clause, rather, and it said BC law. The BC company sued the American company. The American company didn't defend. BC got a judgment, went down to Missouri, went into a court, said they wanted to register the judgment. And the U.S. judge said, it looks like laws of Mississippi and the laws of BC conflict. Sure, BC law should apply, but not necessarily to the exclusion of Missouri law. And then he said, and no BC court is going to tell me what I can do. So now we put in a choice of law clause to the exclusion of conflicts of laws. In addition, all 3 countries are signatories to NAFTA then, or the Canada, U.S., Mexico agreement, or the WTO or the IBUS, the International Convention on the Sale of Goods. So you had better include a clause to opt out. I almost forgot. So whenever you've got a contract between a Canadian company or an American company and a civil law country, you want to opt out of the International Convention on the Sale of Goods. Why? Because it is predominantly civil law, and we are all signatories, and we have all had enabling legislation passed. So the International Convention on the Sale of Goods will apply to every contract when it's international, unless you opt out. So it would be absolutely ludicrous for a Canadian company and a U.S. company to have a choice of law clause and have it overridden by an international convention that says civil law should apply. So you want to make sure that it's a choice of law clause that excludes conflicts of laws, and you opt out of the International Convention on the Sale of Goods. And then, of course, when you're dealing with Mexico, I brought it up in the video, and I hope you remember that the Mexican government requires a clause in there saying that this contract has been fairly negotiated, whether it has or not. But if it, I had a company in Canada sign a contract with a company out of Delaware, and they had this really tight agreement done by the Delaware company, and it said this contract has been fairly negotiated, but it hadn't been, okay? And the big company had really beaten up on my client's company. My client told me, hey, listen, we don't care. We're going to make so much money that, we'll sign anything. And it worked out fine, okay? It was a really one-sided agreement, but the company out of Delaware wanted to make money. My client wanted to make money in it, so it worked. But they're afraid of American companies beating up on Mexican companies, so the Mexican government said it has to be fairly negotiated. Go to court in Mexico and try to enforce a contract that says it's been fairly negotiated. If it's one-sided, the Mexican government will strike it down. So you want to make sure that that clause is in there, because it has to be, or the contract is void, and you want to make sure that you've tried to fairly negotiate it. All right. So then we get on to the third case. Just going to check to make sure how we're doing here. Yep, okay. Juan Armando Felipe Calais Montejo, a recent Canadian citizen of Guatemala heritage, was upset at the treatment of Guatemalan undocumented immigrants kept in crowded cages in the United States along the U.S.-Mexican border. Some 26 Guatemalans had died. Senior Montejo had tried to get numerous BC lawyers to take his case. Although none of the victims were relatives of Senior Montejo, he had wanted to start an action against President Trump for causing wrongful death, but the lawyers had all refused. A lot of Republican senators are gutless and won't stand up to Trump. A lot of government people in the United States won't stand up to Trump. But you got to wonder about the United Nations, because the United Nations takes action against so many countries for human rights disputes, and yet it's pretty obvious that what the Trump government did along the Mexican border with regard to undocumented immigrants and separating them from the children from the families is a human rights violation, but the United Nations hasn't done anything. And it's almost like they're gutless too, in the sense that, hey, most of our funding to keep the United Nations going comes from the United States, so let's not take on President Trump, because he might cut our funding. This is Peter Holden on his soapbox. I just sort of wonder about these things. Anyway, I'll get down off my soapbox and come back to the contract, or the exam. All right, so anyway, he wants to start this causing wrongful death suit and sue and sued President Trump, and he was surprised when the matter was dismissed. Now he had written to the AG of Canada for assistance. Well, said Sue, an action for causing wrongful death is a civil private law matter, and so it was commenced in the Municipal Civil Court, of Canada. I read the transcript of the decision of Madam Justice Grumble of the Ontario Court of Appeal. Shouldn't have been the Ontario Court of Appeal. Oh well, doesn't matter. The action was dismissed on 3 grounds. While there was a recognizable cause of action, causing wrongful death, Monteo lacked standing to sue or jurisdiction. Standing to sue. Why? Well, that would be like me suing for a contract dispute between Graham and Jones. Like, I don't have anything to do with it. So how can I possibly have standing to sue? Something that you should have covered in BAD M107. We covered it last term in international business because there was such a small class that we decided that we were going to have do a court case. So we did one of the projects, instead of just memo teams, we had actually a court team. We couldn't do that this year because you have to have a court case and be there, really. Anyway, so he lacks standing to sue. More importantly, the justice advised Senior Monteo that he cannot sue the President of the United States because he has a big a group of lawyers that are going to fight for him. No, he has the Department of Justice of the United States helping him. No, he has sovereign immunity. Sovereign immunity. And finally, because of something which stands for the proposition that a government is not subject to the scrutiny of foreign courts for its actions within the boundaries of its own jurisdiction. So sovereign immunity for President Trump, and the Act of State Doctrine says whatever the United States wants to do within its borders, no matter how despicable, no matter how horrible, no matter how criminal, no matter how disgusting, taking kids away from their parents. I cannot imagine the horror I would feel if President Trudeau or Prime Minister Trudeau said, hey, guess what? I'm going to take your child away from you for some ridiculous reason. Anyway, the Act of State Doctrine says whatever they do within their borders is their own business, with the exception of the United Nations, who could have brought a human rights tribunal action against the United States, but didn't. Okay, so that's that one. Oh, well, no, actually, it goes on. Maybe it could be taken to the International Criminal Court of Justice. I would accept almost anything there because I don't think I covered it as well last year. The International Criminal Court of Justice was established by the United Nations, and yes, almost every country in the world signed it. Well, no, most countries signed it. Russia, United States didn't sign it. Why? Because it would curtail their ability to just grab a terrorist and put him in Guantanamo. And Russia backed out of it after signing it because it was going to interfere with their ability to go into the Ukraine. So it's pretty much of no use. There is one case there that is in its 12th year, and they still haven't had a decision. A criminal case in Canada would be dismissed if after 12 years there had been no decision, because it would be justice delayed, justice denied sort of thing. Anyway, we didn't discuss it enough last year, so I allowed everything, or just about anything there to get the mark. Can you take it to the International Criminal Court? I doubt it, said Sue. While the U.S. Immigration and Customs Enforcement may have committed the guilty act, actus reus, the ICE officers lacked the mens rea needed for criminal conviction. because the U.S. withdrew from the convention establishing that court, and so there would be a lack of jurisdiction. Okay, but don't worry about that. That was last year, and I don't think it's on this year. Okay, I'll do the memo in that case, says Pendens. Then the duo took the file from another file from the file. France had instituted duties on Canadian wines imported into the country. Canada was taking the position that the duties did not constitute a protection of an endangered industry and were therefore wrongfully instituted. Okay, what's this? Diplomacy, International Court of Justice, International Arbitration, International Tribunal, Municipal, Domestic Courts, Private Arbitration. Those are your choices. Go down the list. Diplomacy would probably happen, but International Court of Justice, no. International Arbitration, oh, wait a minute. WTO settles disputes over tariffs and things like that. So obviously the answer is the matter is international arbitration, and Canada should request the establishment of a resolution panel under the provisions of the WTO, and Canada had a similar successful case last year against Canadian wines exported to Spain. But remember, the WTO is not bound by, okay, obviously stare decisis is what we're talking about here. The WTO is not bound by precedent, okay? The panel would obviously be cognizant of other cases that have occurred, all right? But because most of the nations in the WTO are not common law jurisdictions, they are not bound by precedent. Okay. All right, but if the panel finds the reasoning persuasive, the panel will likely follow it. I'll do the memo on that one. Sue went to take another file from the pile, but Pendens stopped her. "It's quitting time for the day," said. But May said, "There are still so many files for us to review," to which Liz replied, "This is a government job. You may get brownie points from the Deputy Minister or writ, but no overtime pay. Besides, I'm pretty certain that all these files will still be here tomorrow morning. Good evening, May. It's great working with you." After Pendens had left for the day, Sue who was used to working long hours as a clerk for Madam Justice Grumble, could not help herself. She took one more file home to work on. The Attorney General of Canada had a high-profile case coming up before the International Court of Justice, and he asked for a list of the law which the court applied. She thought back to her international law course at McGill and made a list for the AG. Obviously, this is Article 38 of the Convention that established the International Court of Justice. It's in the materials, and it is treaties, conventions, international custom, general principles of law, judicial decisions, and the teachings of the most highly qualified publicists of various nations. The AG's last question was, how many justices generally sit on the International Court of Justice? It should be an ICJ suit. Sue answered, and then put the finishing touches on her governing memo and called it quits for the day. I gave everyone a mark for that. I covered it in the lecture, but I really didn't highlight it, and so I guess nobody took notes on it. They actually have 12 justices sit, which right off the bat could be a problem if 6 said one and six said the other. But I don't know whether that's changed or not. But that won't be on this year's exam. Okay, so how do you tackle Part C of this year's exam? You list those 6 methods of resolving disputes. Under diplomacy, you would probably put 2 subheadings. The negotiation and conciliation between the countries. The third country steps in and uses its good offices. Under International Court of Justice, put down International Criminal Court of Justice, not effective. International Civil Court of Justice, those 38, Article 38 sources of law. International arbitration, you put down WTO and the World Bank's Convention on the Settlement of of Investment Disputes, the ICSD. And then under International Tribunal, this is the Canada-U.S. Mexican Agreement. Okay, it's the dispute resolution panel is still in effect. Trump said he wanted to get rid of it. I think that was just one of those negotiation things, because initially matters that went to the a binational panel and then a multinational panel after Mexico joined, Canada was winning, Canada was winning, Canada was winning, and the United States didn't like it. Lately, apparently, the United States has been winning more. I don't know whether there's any bias there or whether it just happens to be the nature of the cases. Okay, municipal domestic courts didn't do much in Part C last year, so you might get a heads up that it would be in Part C this year. But that it was question 1 in Part B that covered that. Okay, and I posted that material on the real and substantial connection doctrine and the most significant relationship doctrine. And I talked about it the other day, and everybody went, "Ooh, and you're confused." And I apologize. I'd like to say it was clear, but it isn't clear. Okay, that's just the law. Anyway, I said that I would do a little video and try to clarify it a bit more, and I will do that and post another video. Anyway, this is the video on the last year's midterm exam, and if you have any questions, you can either ask me or you can actually just say, hey, there's quite a few students with questions, can we have a Zoom session? But as I mentioned, November 2nd, Part A and Part B, November 4th, Part C. Thank you very much.